Hey there. So today I'm going to show you exactly how to fill out a Texas durable power of attorney and a Texas will using the free form fillable PDFs that come with my book, Estate Planning in Texas. I'll walk you through each step on screen so that you can feel confident, completing your own estate plan. But look, before we start, I want to be clear. This kind of doing estate planning yourself, it's not right for everyone. Some people, many people, have more complex family situations, have blended families, have conflict among heirs, have large estates, or maybe need special tax planning. And all of those circumstances are explained in my book. And those situations need, personalized legal advice and personalized legal services. But for many Texans with really simple, straightforward wishes, especially if you prefer to handle things yourself, these forms can help you put a basic plan in place. So today I'm going to walk you through exactly how to complete a Texas durable power attorney and a Texas will using the fillable forms that come with my book. All right, so let's jump in. Let me show you, first of all, let's see. So, oh, there we go. All right. So here's the book cover, and purchasing the book gives the viewer or the reader free access to the Texas specific fillable forms, including multiple will versions and powers of attorney. So there are smart text fields, so you can type your name once and it fills everywhere it needs to go. All right, so first thing I'm going to do is I want to introduce the power of attorney to you. So virtually every adult in Texas needs a power of attorney. The reason power of attorney is important is if at some point during the rest of your lifetime you get to a point where you can't sign your name, you can't transact your IRA that's in your name, you can't deal with the IRS or tax returns, or maybe you can't, transact a vehicle that's in your name that needs to be sold or purchased. If you don't have that power of attorney in place, then it's likely that some family member or somebody's going to have to sue you in a guardianship proceeding, have a court declare you incompetent, and have a court or judge appoint a legal guardian for you. And so having that durable power of attorney in place can replace all of that court involvement if and when you become incapacitated. And with your power of attorney, you get to designate who you'd want being able to handle those things if you were unable to handle them for yourself. Okay, so let me jump into that. I'm moving around the tabs here, but let me show you what that looks like. Okay, so here is a here is the Texas statutory durable power of attorney. So, the Texas legislature created this. The idea is, hey, Texas legislature created a form commonly used. The Texas Bank, the Texas financial institutions are familiar with it. And so they don't have to do as much legal review as if you had submitted your own kind of customized power of attorney. So this is it here. It's several pages. You get to fill out certain things, but this is how you would fill it out. Let's say your name was John. Uh, let's see here, John Doe, and you lived at 123 Sesame Street, and you put your city and zip. And then maybe you'd want to appoint, and most married people want to appoint their spouses. So Jane Doe as the agent, and Jane Doe also lives at 123 Sesame, Street, city and state. And so that's how you fill it out and you appoint who you'd want. Now, you do have the ability to withhold or grant certain powers. Most people end up just granting their agent, all of those powers that exist. But if you do want to limit or modify what powers your agent would have, you can do that by initialing certain things. You would actually print this out and then you'd put your initials in the appropriate blanks where you want to, grant or deny certain powers. And then, there's places where you can initial about whether you'd want your agent to get compensation. We like the idea of having one agent and then a backup agent. Some financial institutions won't work with two people who have to work together on a power of attorney. And so we always have you designate one and then an alternate. Most people don't fill this out on special instructions, but some people have them. And you can choose whether the power of attorney is effective immediate, meaning once you sign it, your agent that you designated can transact for you, or you can designate that the power of attorney becomes effective only upon your disability or incapacity. So some people feel a little more comfortable that way. They say, hey, as long as I'm able, I want to be the only person who can transact for me. But if I become incapacitated, that's when I want my agent's powers triggered. And then if you want to, you can appoint, another Fred Doe. Maybe you have a, responsible, mature adult son named Fred. And, he lives at 567, whatever street. And so but then you have to kind of the most important thing is you can't sign. Texas law does not permit you to sign these documents electronically or digitally. They have to be printed out. So, that's what you'll have to do. You'll have to print out your documents and get yourself in front of a notary and get them signed that way. So, okay, so that's the Texas Durable Power of Attorney. Every adult in Texas should have one. And you can get that and do what I just did. If you purchase my book, get the free access code, go to my website and download the forms. Okay, so the next thing, let me bounce around, get myself situated here again, is next thing I want to go over is I want to introduce you to a kind of Texas specific will. Of course, wills are tricky because there's so many people have so many different family circumstances. But, when you purchase my book, I've created really 6 different will forms. We're just going to go through the kind of basic married couple one. It's the married couple will or married person will that says, when I pass away, I leave everything to my surviving spouse. That's what I call leaving ownership to your spouse. Real simple. You die, your spouse is alive. Your spouse continues owning what they own, and then what you own, you leave to your spouse, so your spouse owns it all. Really good from a tax standpoint, and I'm not talking about the federal estate tax, which allows married couples to leave $30 million free of the estate tax, but I'm really talking about the capital gains tax. Is when you pass away, leaving a surviving spouse, all of your community property gets a step up in basis, and by leaving your part to your surviving spouse, it'll be included in your surviving spouse's estate. Yes, they can exempt 30 million from the 40% federal estate tax, but the key is all of those assets will get another step up in basis when your surviving spouse dies because they're included in her estate. So that's the tax benefit of leaving everything to your surviving spouse. Yes, the kind of knock on leaving ownership to your spouse is that your spouse could remarry, your spouse could get influenced, your spouse could make a stupid decision. And with one stroke of a pen, leave not only your spouse's part, but your part that you left to your spouse. Your spouse could leave all that to people other than people that you'd want your spouse to leave them to. Most people say their children. So your surviving spouse could disinherit your child. That's the risk of leaving everything to your surviving spouse. But over the years, as I've talked to thousands of people, many people say, no, we're comfortable leaving ownership to our spouse. We know or we feel like our spouse wouldn't do anything silly, and we want to make sure we get that double step up in basis. So let's do that. So okay, so let me show you what we have there. And again, I'm going to get to the right screen. And so, and then of course, in this will, you're saying you're leaving your estate to your spouse. And then if your spouse predeceases you, then you're leaving your estate to your children. And again, the terminology for that is your descendants per stirpes. Those 3 words, descendants per stirpes, covers a lot of circumstances. It leaves everything to your children equally. But if a child passes away before you and the child had children, then the child's share will go to the child's children. And on the other hand, if a child predeceased you and they didn't have children, then your child's share would go back to your other children. So that descendants per stirpes is really what a lot of people want in how they want to leave things to their children or to their descendants. So let's take a quick look at that. All right, we've got this here. And so there's a few little instructional pieces here. So for example, and again, you get this form along with so many others when you purchase my book and get the free access code. So let's say your name is John Doe, and by filling it in, as soon as you advance out of that tab, it populates your name and all of the other places where your name needs to be in your will. So it doesn't have to be typed multiple times. Married to Jane Doe. Okay. And then I leave my estate to my spouse. Okay, good enough. You pass away, it all goes to Jane. If my spouse predeceases me, I leave my estate to my descendants per stirpes. So that means it goes to your children. And presumably Jane would have her own will that would be just like this, where she'd leave things to John. And then if John predeceased, she'd leave things to her descendants per stirpes. So this is ideal for that kind of traditional family, husband and wife have children. If a beneficiary is under 25 years old when you pass away or when the surviving spouse passes away, things will be in a trust for them so they don't blow it. Here's where you name your executor. Most married people say that they want their spouse to be their executor. Maybe they have an adult child named Fred who they'd want to be the alternate executor or the executor when the surviving spouse dies. And again, there you go. And then again, the key is making sure you meet all the signature validity requirements, so you've got to get yourself in front, print it out. No such thing as digital signatures on a will in Texas. So you've got to go ahead and go through the process of, printing it out and making sure all of the validity requirements and signature requirements are met just right. And this will kind of walk you through that. All right, so that's that. All right, so as we go back here and kind of take a final wrap up here. Okay, so again, to access these forms, you order my book, Estate Planning in Texas, on Amazon. It releases on Thursday, December 11th, 2025. It's the 2026 version, updated for 2026. There's a link in this description of the video and in the comment where you can order the book. Make sure you leave a review. A quick Amazon review helps more Texas families find these resources. And make sure you use your free access code in the book to go to the website and download the form. So I hope this walkthrough gives you the confidence to just take whatever next steps may be appropriate for your family. Have a great day.